All right, good afternoon, Mr. Schmidt. Are you ready?
So, I'm a left-handed writer.
All right. Is this Mr. Fulbright?
It's Marshall Parker, sir.
Okay. Marshall Deshaun Tucker, CR 2331. Mr. Parker, is he going to be entering a plea to the court today?
Yes, sir.
All right, Mr. Parker, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thanks, sir. You can lower your hand. Mr. Parker, your name is Marshall Deshaun Parker. Is that correct?
Yes.
And Mr. Parker, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
And in this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you understand everything that you have read and signed that's part of your plea agreement?
Yes, sir.
Do you have any questions before we go forward?
No, sir.
Mr. Schmidt, I'm assuming that Mr. Parker, in your opinion, is competent to enter into this plea, and if so, that he's doing so intentionally, knowingly, and voluntarily after you have advised him of his rights.
Yes, sir.
All right, Mr. Parker, you are charged by indictment with a third-degree felony offense of unlawful possession of firearm by a felon. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison, and a fine not to exceed $10,000. I see the plea agreement in your case is, upon your plea of guilty, the state's recommending that your punishment be assessed by the court at 5 years confinement in prison, 0 fine, 0 restitution, $290 in court costs, and $85 in reimbursement fees. Is there a weapon forfeiture associated with this at all?
I would assume there would be, Judge. I'm looking at the judgment.
I don't see one.
I don't see one on the judgment either. So.
I believe Mr. Hartwell is looking up to see if there was a weapon seized. While he's doing that, I'm going to go ahead and continue and ask you a few questions, Mr. Parker. Is that your understanding of the plea agreement at this time?
Yes, sir.
And Mr. Schmidt, if there was a weapon seized and if the state moves to forfeit that weapon, will there be any objection by the defendant?
As to the defendant's right of possession, we have no objection to that.
All right, Mr. Parker, understanding the range of punishment, understanding the plea agreement in this case, I ask you now, how do you plead to unlawful possession of firearm by a felon?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, sir. It appears that the firearm was seized. They would ask that forfeited.
And Judge, I can't hear the state.
I'm sorry, and that's my fault. I had to turn off the microphones because they were really acting up. All right, go ahead. Start again, Mr. Hartwell.
Yes, sir. It appears that the firearm was seized. Smith must have had a $9 state would ask that the forfeited serial number NLD 4008.
Any objections, Mr. Schmidt?
I believe the state stated that they had a firearm and he read out the serial number. Is that correct?
That's correct. Do you want him to state what it is again?
If it was seized, we have no objection as it pertains to Mr. Parker.
Okay. All right. Anything further, Mr. Hartwell?
Nothing further.
All right. Anything further from the defense?
No, sir.
All right. Court's going to review the evidence. All right. Based on the evidence before the court finds that there is sufficient evidence to convict the defendant of the offense. The court follows the plea agreement. Court hereby convicts Marshall Deshaun Parker of unlawful possession of firearm by felon, assesses his punishment today pursuant to the plea agreement at 5 years confinement in the Texas Department of Criminal Justice. The court orders him to pay court costs of $290 and reimbursement fees of $85. The court awards Mr. Parker 333 days credit towards his sentence for the time that he spent in jail on this cause. And the court also forfeits the weapon that was seized as part of this offense. Court is asking the state to have that reflected in the special findings on the last page of the judgment.
Yes.
Mr. Parker, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Mr. Hartwell, if you'll move that microphone away from the bottom of you, like, no, this way. It's a boundary mic, so the further away it is, the more it'll pick you up. All right, who's next?
Casey Spriggs.
All right, Mr. Spriggs, let me get back here. This is cause number CR 21371, State of Texas versus Casey Lynn Spriggs. The court had set Mr. Spriggs' motion for suppression, I believe, of a statement today. It was previously set by counsel, Mr. Casey Ashmore. Since the prior setting in this case, Mr. Ashmore has filed a motion to withdraw and also a motion to continue the evidentiary hearing in this case. The court, having reviewed the motion for withdrawal, has granted that. The court has appointed Mr. Spriggs, who the court finds is still indigent at this time, counsel in the appointment of the Honorable Richard Schmidt. And the court, having also granted the continuance of the evidentiary hearing, Mr. Schmidt, I'll give you time to familiarize yourself with the case. And should you want to adopt any of those motions filed by Mr. Ashmore and request a hearing, the court will grant that. But at this time, I was going to ask how you wanted to set the case at this time to give yourself a chance to get caught up.
Judge, just for the court's awareness, I received the written discovery from the portal. I've got to provide the DA's office with a thumb drive to get the digital and talk to Mr. Ashmore and Mr. Spriggs and Ms. Curry. So I believe if the court could set us for just a standard pretrial hearing, I will either adopt or abandon prior motions filed by Mr. Ashmore or file additional motions that I may need.
Yeah, the court is familiar with the voluminous amount of discovery in this case. So, Mr. Schmidt, what about August 13th?
Should be fine, sir.
All right, court sets Mr. Spriggs for a status hearing on August 13th at 1:30. And should there be a need to set that earlier, Mr. Schmidt, I do have dates available. You can contact the court and I can set it earlier if needed.
Gotcha. Thank you. Dugan, come on.
Who did you say, Mr. Schmidt?
Dugan Thomas.
Dugan Thomas. Okay, thank you. All right, this is cause number CR 22-158, State versus Dugan Lee Toms. I believe that we were set for an evidentiary hearing today. Go ahead.
No, sir, we were set on a motion to proceed on Mr. Tom's. We've reached an agreement with the state. We'd asked that it be set for a plea.
My next available would be July 2nd.
Do you have a little bit later date than that?
I've got July 2nd, July 9th. Those are the 2 Tuesdays in July.
July 9th should be fine.
All right, court sets Mr. Tom's for plea on July 9th at 1:30. All right, who's next?
This is Jeffrey Mills.
Jeffrey Mills, CR 21-229. Is Mr. Mills entering a plea today?
No, sir.
No? Okay. So good. Go ahead, Mr. Schmidt.
And Judge, we've received an offer from the state. I had ample opportunity to discuss that offer in the case with Mr. Mills. At this time, we would announce ready for trial.
Okay, and let me ask and make sure we have on the record here. So the offer that was extended that I thought Mr. Mills was going to be entering a plea to today was a finding of guilt be deferred on an injury to a child with intent to cause bodily injury, deferred for 6 years community supervision, a $2,000 fine, $290 court cost, and $570 reimbursement fees. And is that the offer that was extended that Mr. Mills is rejecting today?
Yes, sir.
Okay. All right. And Mr. Mills understands that the court may not allow him to enter a plea after this date if he requested a trial.
Yes, sir. We discussed that.
Okay. All right. Court finds that Mr. Mills, having rejected the offer made by the state, will set Mr. Mills for jury trial. This being a sexual offense against a child. The court may end up special setting this, but at this time, I'm just going to place him on the jury trial docket beginning on August 5th. And I will discuss with Ms. Taberham if there's an opportunity for a special setting.
And Judge, we have Zakorian and Fulbright, the state filed a motion, find his bonds insufficient. We withdraw any objection to those, so we will not need a hearing on the state's motion.
Okay, then the court, having reviewed the state's motion to find bond insufficient, court hereby grants the defendant's motion, finding that there is no objection by the defendants.
And Judge, just for the record purposes, we do not adopt the contents of the state's motion or the allegations therein, but we do withdraw objection to the court finding his bond insufficient for other purposes. So just so the court's aware that we're not
Yes.
agreeing to the contents.
Yes, sir.
Oh, do we?
There's no objection.
Oh, well, we might, hey, come on down, so. Judge, if we call this case, I think initially we had announced ready for trial. I asked the court to set him on the 18th for a potential plea. Under the circumstances, I believe the state intends to revoke that offer, so we need to get him a setting.
All right, for the record, this is cause number CR 22-214, CR 23-138, CR 23-139, State of Texas versus Zakorian Fulbright. And it's just so for clarification, so that I understand, you're asking to reset the case to determine if the state is still willing to extend whatever offer was made to Mr. Fulbright that you expected Mr. Fulbright to accept?
Yes, sir, and I know I've had conversations with Mr. Hartwell, and he has not made a definitive revocation of the prior offer, but he intimated that he would likely have to reconsider, so if we could reset him to either plea or announce ready for trial, that would be, otherwise he has no additional settings on file.
Mr. Hartwell?
Yes, Your Honor, at this point, the state would formally withdraw its offer, pending review and possible indictment or expected indictment of the new charges. And we'll be in contact with the defense as far as whether we intend to extend another offer that would be inclusive of all pending and current charges.
If I reset this for July 9th, do you believe that you could make that offer if one's going to be made?
Yes, sir.
All right, court will reset Mr. Fulbright for a final docket call on July 9th at 1:30. And so whatever final and best offer is going to be made from the state, I would ask that that be made and given to Mr. Fulbright and Mr. Schmidt to where they could do some meaningful consideration of that prior to July 9th. All right, good afternoon, Mr. Manning.
Good afternoon, Judge.
Who are you ready on?
We can start with Mr. Capps, Thomas Capps. Judge, I think he was on the first couple pages of the docket. He was set for 1:30, but he was on the first couple pages of the court's docket.
All right, this is cause number CR 23-45, State versus Thomas Allen Capps. Mr. Capps, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You can lower your hand. All right, let me see. I don't know that I have the paperwork here for Mr. Capps.
Judge, I was just appointed this afternoon for his representation on his motion to revoke that was filed by the state on May 16th of 2024.
Okay, do you want to set him for a status on the motion to revoke, or do you want me to just go ahead and set him for the contested docket on July 30th?
Well, Judge, the only allegations at this point in time are the a new offense that's unindicted at this point in time. If we can set it for a status, I would appreciate that.
Does the state know if Mr. Capps may be going before the grand jury before the next contested date?
Your Honor, I'm not 100% sure. I do see the charge. I don't know. I don't know yet if the plan is to take it to grand jury this month or if it's been fully reviewed yet.
Judge,
Alright.
I was unable to hear the announcement by the state.
I don't want to try to repeat what Mr. Harwell said because I don't think I get it right. But how about I just set you for August 15th on a status? In summary, I think he says he's not sure when it's going to go to grand jury.
Judge, if we're going to set it out that far, I would request a bond to be set on Mr. Capps' case. We are contesting the innocence of this new offense, and as is the only allegation, we'd like for him to be able to continue working his multiple jobs, continuing on his conditions of probation as he has been, and we request a bond be set for Mr. Capps.
I think if you want to do that, you'll need to give notice to the state and give them an opportunity to prepare for that hearing. I can set it for July 11th. I was just trying to give you more time to get your hands around the new case if there is going to be one. Do you mean set it on July 11th?
Judge, that'd be fine. That'd be fine.
All right, we'll set Mr. Capps then for a hearing on the motion to revoke and the motion to set bail on July 11th at 1:30.
Sorry, Judge, that was July 11th, is that correct?
July 11th, correct.
Judge, next ready on Mr. Collard.
Anthony Dale Collard, CR 21-110. Motion to revoke.
Judge, I just recently been appointed to Mr. Collard's case. I've had an opportunity to sit down and go over his case with him. I would like to set this for the contested docket in July.
All right, court sets Mr. Collard for contested hearing July 30th at 1:30.
Next ready on Mr. Gibson.
Marcus Lynn Gibson, CR 24-98 for arraignment. Do you need that indictment?
Judge, we have actually already gone over the indictment. The state provided discovery prior to this hearing. And Mr. Gibson and I went over that discovery earlier this week. His name misspelled correctly. He understands the charge against him as well as the range of punishment, pleads not guilty, and requests to be set on the pretrial docket.
All right, court finding that Mr. Gibson has waived the formal requirements of arraignment, enters his plea of not guilty into the record and sets this matter for pretrial hearing. Do you want that July 11th? Or is that too soon?
Judge,
The next,
if we-
the
if
next
we have-
date after that would be August 15th.
Judge, if we may have that August 15th date.
All right, court sets Mr. Gibson for pretrial August 15th at 1:30.
Judge, next we have Mr. Mata, Christopher Mata.
Christopher Jean Mata, CR 20-261.
And Judge, on this one, we'd also like to request to be set on the July 30th contested docket.
All right, court sets Mr. Mata for contested hearing on July 30th at 1:30.
Judge, we received an offer and my client has asked for me to make a counter offer. After I communicate that, if we have reached an agreement, would it be possible to set him earlier?
Yes, sir, absolutely.
Thank you, Judge. Judge, next we're ready on Mr. Hazel.
Joseph Ryan Hazel, CR 19-233. All right, so Mr. Hazel going to enter a plea today?
Yes, Judge.
All right, Mr. Hazel, if you'll raise your right hand, sir. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Swear.
Thank you, sir. You can lower your hand. Your name is Joseph Ryan Hazel, correct?
Yes, sir.
And Mr. Hazel, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
I sure do.
Do you feel like you've had enough time to talk with him about your case and that you've had all of your legal questions answered and that you understand everything that you've read and signed in your plea agreement?
Yes, sir.
All right, Mr. Manning, do you believe Mr. Hazel to be competent?
I do, Judge.
And you've explained to him his rights as they pertain to this case?
I have.
And do you believe he to be entering into this plea intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Mr. Hazel, I see that you are charged by indictment with a third-degree felony offense of driving while intoxicated, third or more. that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000 if imposed. I see also that the plea agreement you've reached with the state is that upon your plea of guilty, the state's recommending that your punishment be assessed at 7 years confinement in the Texas Department of Criminal Justice, fines of a fine of $3,100, restitution of $60, court costs of $290, and reimbursement fees of $135. You would also receive credit towards your sentence for the time that you've already spent in jail, which is 248 days. Is that your understanding of the plea agreement?
Yes, sir.
All right. Do you have any questions before we go forward?
No, sir.
All right, Mr. Hazel, how do you plead to driving while intoxicated, third or more offense?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
No, sir.
Has anyone, well, let me, are you pleading guilty because you are guilty, not because you want a certain plea agreement?
No, sir.
Okay, I think I understand. You're pleading guilty because you are guilty of this offense, right?
Yes, sir.
Okay, you're not doing it for any other reason.
No, sir.
Okay, all right.
I may be getting it messed up.
It's okay. Well, I'm sure the question could be improved, but
Okay.
I just want to make sure. If it makes me scratch my head, I'm supposed to stop and ask more questions, but I think we're on the same page now. Mr. Manning, is there any objection? Well, the court's going to go ahead and accept Mr. Hazel's plea at this time. Do you have any objection to the stipulation of evidence supporting the plea?
Judge, we were not provided with the stipulation of evidence. I thought that might be forthcoming. But we have not received a stipulation specific to this case.
Let me see if I have one here. Mr. Hartwell, do you, or Mr. Hernandez, do you have a stipulation of evidence?
I do, Your Honor, and I just apologize. I had sent that out, but I don't have anything. Perhaps when I send that.
Do you have it typed up already?
I do.
Can you, if you want to, I'll authorize you to share. If you just want to share that on screen so that they can review it.
Yes.
Judge, that matches our understanding of the facts and evidence in this case, and we have no objection to state's one stipulation of evidence.
All right, then the stipulation of evidence is admitted and the court does take judicial notice of Mr. Hazel's judicial confession. Anything further from state?
Nothing.
Anything further from the defense?
Rest of those, Judge.
All right, then the court, having reviewed the evidence, finds that there is sufficient evidence to convict the defendant of this offense. The court does follow the plea agreement today and recommendation by the state. The court convicts Joseph Ryan Hazel of driving while intoxicated, third or more offense. Court assesses punishment pursuant to the plea agreement at 7 years confinement in the Texas Department of Criminal Justice, orders him to pay a $3,100 fine, $60 restitution, $290 court cost, $135 in reimbursement fees, and the court awards Mr. Hazel $248. I'm sorry, 248 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Hartwell, if you'll email that out to the jail so that we can have Mr. Manning sign that along with Mr. Hazel, the stipulation of evidence, I'd appreciate it. Mr. Hazel, you hereby remanded to the custody of the sheriff so that he can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted. Good luck to you, sir.
Thank you.
All right, who's next, Mr. Manning?
Judge, we're still waiting a correction on the credit time for Mr. Watkins. He successfully completed state P. But if you want to go ahead and go forward with the plea, I can give the court the dates that I anticipate he should be getting the credit for.
Are you in consultation with the state or Ms. Abney on that?
Judge, I sent an email and I also had the probation department send over confirmation of the safety completion. I don't know what the status is of the paperwork.
Yeah, I'd rather wait until everybody can agree that the credit time is the credit time. What
Yes,
about what about Miss Opera? Is she in there?
Judge, she has not been brought in yet, but if you'd like, we can take a short recess and I can get her paperwork done up to make sure it's correct.
Yeah, let's go ahead and do that, and then we'll deal with Mr. Watkins whenever y'all have a chance to look at the credit time.
Thank you, Judge.
Have you, Ms. Taberham, have you communicated with Mr. Huggins regarding Mr. Green's illness?
Yes, Your Honor, and he has signed his reset.
Okay. All right, and so we said 7-11 for motion to revoke status.
Yes, Your Honor.
All right, that is cause number CR 20124. State versus Hunter James Huggins. Court finds that Mr. Green has contacted the court, indicated that he's ill today. And so the court is resetting this motion to revoke hearing to July 11th at 1:30. Is Mr. Schultz available or Miss McQuarrie?
No, we were waiting to bring the two females in. Mr. Johnson is here representing Miss McQuarrie, and we are waiting on some paperwork on her.
Okay, Mr. Johnson would, what's his first name?
Paul Johnson.
Paul Johnson. Okay, I'll write that in.
And
And you said Schultz has not been brought up yet?
no, we will get the last three in here.
Okay, all right, we'll stand in recess.
All right, thank you, sir. Your Honor.
Yes, ma'am.
Okay, Mr. Schultz is in here.
Okay, I'll call him up in just a few minutes.
Okay.
All right, Ms. Abraham, are you ready?
Yes, Your Honor. Who do you want to start with?
Let's start with the attorneys.
Okay.
I think Mr. Johnson was ready.
Mr. Johnson?
Yes, sir.
All right, this is cause number CR 20-347, State of Texas versus Melanie Renee McQuarrie. All right, what are we doing today on Miss McQuarrie? Go ahead, Mr. Johnson.
Judge, we have reached an agreement with the prosecution that the probation be continued with the addition of intensive supervision probation program.
Okay,
That's correct, Your Honor. The state would be moving to draw a motion.
okay. And is probation in agreement?
They are.
Yeah.
Fight that with the probation officer, and she said that would be the only way that she would be accepted back into probation.
Okay. All right, then the court will grant the state's motion to withdraw the motion to revoke. The court will amend the conditions of community supervision for Ms. McQuarrie to include placement on the intensive supervision program. All right, Ms. McQuarrie, do you have any questions?
No,
Okay, all right, I'll get that signed and then you'll get processed out of the jail and then make sure you stay in contact with your probation officer. All right,
Thank you, Judge.
thank you, Mr. Johnson, appreciate you.
Thank you, man. Thank you. Okay.
All right, Mr. Manning.
Great, Judge. Mr. Watkins?
All right, what do we come to find out on the credit time?
Judge, they were able to conclude that he had 483 days credit. That's 483. And that matches my client's recollection as well as what I was able to confirm through looking through his jail records and probation records.
Okay, good. All right, court calls cause number CR 20-201, State of Texas versus Michael Watkins. Mr. Watkins, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
sir.
Thanks, sir. You can lower your hand. All right, Mr. Watkins, you came before the court previously on June 15th of 2021, and you pled guilty to the third-degree felony offense of evading arrest or detention with a vehicle. The court heard the evidence, found that there was enough evidence to convict you. The court followed a plea agreement that day, assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice. The court also ordered you to pay a $2,000 fine. The court then suspended that sentence and placed you on community supervision or probation for 4 years. And it was during that period that the state filed its motion to revoke. And in that motion to revoke, they have alleged 6 separate counts of various allegations regarding violations. Have you had enough time to review that motion with your attorney, Mr. Manning?
Just the violation report. Yeah.
You've had enough time to review and talk to Mr. Manning about this motion?
Yes, sir.
All right. And do you understand everything that you've read and signed that's part of your plea agreement today?
Yes, sir.
And are you pleased with Mr. Manning and the work he's done for you as your attorney?
Yes, sir.
All right. Do you have any questions before we go further?
No, sir.
All right, Mr. Manning, does your client waive the formal reading of the state's motion to revoke today?
He does.
Does he intend to plead true to all 6 counts?
Yes, Judge, I believe that payments were made on some of the conditions, but obviously they weren't made on time. So we understand that still is a violation and could be used against him. However, he would like the court to know that he did pay towards some of those court costs, fines, and probation fees.
All right, that is noted for the record. All right, and Mr. Manning, have you explained to your client all of his rights entailed in this case?
Yes, Judge.
And you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
I do, Judge.
All right, and I see the plea agreement today, Mr. Watkins, is upon your plea of true to those counts in that motion as alleged, the state's recommending today that your community supervision be revoked and that your sentence be assessed at 6 years confinement in TDCJ and ordering you to pay the balance of your financial obligations, which is about $1,685 on your fine and $150 on your reimbursement fees, you having credit for the payments that you did pay already. And then also you receiving 483 days credit toward your sentence for the time that you've spent in jail on this cause. Is that your understanding of the plea agreement?
Yes, sir.
All right, then I would ask you at this time, Mr. Watkins, how do you plead to counts 1 through 6 as alleged? Are those counts true or not true?
True.
And you're telling me that each one of those counts is true because in fact, it is true, correct? You're not just telling me that it's true to get a certain plea agreement.
Right.
All right, then the court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the defendant's waiver of rights and plea of true?
No objection.
All right, that is admitted into evidence and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, no.
Anything further from the defense?
Resting close, Judge.
All right, then based on the evidence before the court finds that Michael Watkins has violated the terms and conditions of his community supervision. The court follows the plea agreement this date. The court revokes Mr. Watkins' community supervision, assesses punishment at 6 years confinement in the Texas Department of Criminal Justice. The court orders him to pay the balance of his fines and reimbursement fees. Court awards Mr. Watkins 483 days credit towards his sentence for the time that he spent in jail on this cause. Mr. Watkins, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over and be fingerprinted with a deputy. When you do get out of prison, if you've not paid off your fines and court costs, you need to report to the courthouse, to the district clerk up on the 3rd floor, and ask about paying those off or getting a payment plan, okay?
Yes, sir.
All right, good luck to you.
All right, thank you.
You're welcome. Who's next?
Judge, next ready on Ms. O'Pride.
All right, this is cause number CR 22280, State of Texas versus Miranda Jill Albright. Mr. Albright, Ms. Albright, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You can lower your hand. All right, let's see here. You appeared before the court on August 10th of 2023, and you pled guilty to the Class A misdemeanor offense of assault causes bodily injury of a family member. The court heard the evidence. The court then convicted you and assessed your punishment at 1 year confinement in the Van Zandt County Jail and also ordered you to pay a $500 fine. The court then suspended that 1 year sentence and placed you on probation or community supervision for 2 years. And during that period, the state filed a motion to revoke and then again an amended motion to revoke. And in their amended motion, they alleged what appears to be 8 separate counts of various violations. Have you had enough time to review the allegations with your attorney, Mr. Manning?
Yes, sir, I have.
And are you pleased with Mr. Manning and his representation?
Yes, sir, very much so.
And do you have any questions before we go further?
No, sir, I don't.
All right. I see that your plea agreement today is upon pleading true to the violations, the state's recommending to the court that your community supervision be revoked, that the sentence be assessed at 130 days confinement in the county jail, with you receiving credit for 70 days of time already served, meaning that you would have to serve the remainder of 60 days in custody, and you would also have to pay the balance of your financial obligations, which is a $500 reimbursement fee. Is that your understanding of the agreement?
Yes, Judge, I apologize. I forgot to speak to Ms. O'Pride about that. I assumed that since she was being sentenced to jail on this, that she would not have that remaining balance for her court-appointed attorney's fees. As you'll note on the judgment, Ms. O'Pride, while not a part of the negotiated settlement, did in fact pay off all her fines, court costs, and get caught up on her probation fees, her back probation fees. And so that's the only portion that we did not discuss was the $500 owed for my representation in this case.
That is a standard cost of court, Ms. O'Pride, because you were indigent. You did request court-appointed counsel, and this court did appoint Mr. Manning, and Mr. Manning is being paid with taxpayer funds. And so that is a court cost that the court's not willing to to waive in this matter. So you would be ordered to pay $500 if the court goes forward with the plea today.
Yes,
And
sir.
you have the right to reject that, if you want to.
No, I don't. I'll get it paid.
All right. Then, Ms. Albright, let me ask you then, having reviewed the amended motion to revoke, how do you plead to counts 1 through 8? Are those counts true or not true? And you're telling me that those counts are true because in fact, what is alleged, is true. Is that correct?
That's
And Ms. Albright, has anybody threatened, forced, or pressured you to plead true to any of these counts?
no, sir.
All right, then the court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection other than clarification that she has paid off all the financial obligations that were due prior to the hearing today.
Thank you, Mr. Manning. Anything further from the state?
Nothing.
All right, anything further from the defense, Mr. Manning?
Rest and close, Judge.
All right, then based on the evidence before the court and the judicial confession of Ms. Albright, the court finds that she has violated the terms and conditions of her community supervision. The court will follow the plea agreement on this date. The court hereby revokes her community supervision, assesses punishment on the Class A misdemeanor offense of assault causes bodily injury of a family member at 130 days confinement in the Van Zandt County Jail. The court awards credit to Ms. Albright for 70 days of time already served. The court orders her to pay the balance of her financial obligations and to serve an additional 60 days confinement in the county jail. Court also orders Ms. Albright to reimburse Van Zandt County $500 for the court-appointed counsel in this case. And Ms. Albright, when you are released, if you can't pay that $500 up front, then report to the district clerk's office and they can arrange a payment plan for you, okay? All right, do you have any questions?
No, sir, I don't.
All right, then Ms. Albright, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted.
Okay, all right, thank you very much.
You're welcome.
Thank you.
Judge, I believe that concludes my business out here. I'll be headed that way with Mr. Huddleston shortly.
Yes, sir. Look forward to it.
Thank you, Judge.
Hey, Mr. Schultz.
All right, this is cause number CR 22-116, State of Texas versus Robert Michael Schultz. Mr. Schultz, as you're aware, the state has filed a motion to revoke your community supervision that was granted in this court. I find that you have requested the appointment of an attorney, and you've indicated that you do not have the financial ability to employ an attorney. And, you know, you and I have had discussions like this in the past regarding the underlying charge that you were placed on community supervision for, because you have assets that are available.
Don't have the assets no more.
You don't own the house and van
I
anymore?
don't own the house, I don't own cars, I don't own vehicles, I call for to work. No, I don't. I support my disabled mother and I support my disabled wife. My wife don't even bring home enough to even pay for utility bills. I don't have a car anymore. I don't have a home anymore. I feel like a sheet. I was honest. I don't really own anything, man.
Where did the house go?
The house is foreclosed on.
Okay, do you have any paperwork that would show that?
No, no, the house is, give it another 2-3 months, it's foreclosed on. It's done.
Did you say give it another 2 or 3 more months?
Yes, yes, it will be foreclosed on and it'll be taken away from it.
Have you already received notice of foreclosure
My house,
proceedings?
yes, sir.
And what about your vehicles that are showing up on these consumer?
They're looking for the Honda car. My wife's pulling in the driveway to get taken. That's the only vehicle we got.
Toyota RAV4?
That's gone. That was repoed about 2 months ago.
Do you have any kind of paperwork on
No,
that?
sir, no, sir, I sure don't. And I'm sorry, but no, I don't have anything to sell. I really don't. I don't have anything to sell. I don't have anything, so.
Okay.
I don't.
All right, go ahead and have a seat and let me talk with Ms. Tabraham and then we'll get back to you.
So who? Who? So you had 3,000 here.
No,
I know, I got that one this morning, but originally, so.
That's what I'm working.
Yeah.
I was, basically, if I'm still in it for another month, I lost my job. I'm gonna get terminated.
Okay, I don't know if you heard that, did you hear him? The 3,000 that he showed as income, he said that he was going to lose his job if he stays in here another month.
Another month, I don't have no more money.
Okay, so I was going by the 3,000 income and his expenses, and then what TransUnion showed was the house on 150 Cherry Lane in Van and the RAV4, 2021 RAV4, I believe it was.
Let's have him do this. The assets that we are showing, let's have him just write out a statement that he doesn't own those anymore under the penalty of perjury, and we'll accept those documents, and then we'll be able to review his indigency status further.
Okay.
So have him just write out and address a statement towards the RAV4, towards the vehicle, towards his incomes, anything else that you're showing to be an asset. Have him write that out, sign it, date it, and we'll get that notarized, and then we'll reconsider.
So we do want to go ahead and reset.
Yeah, let's just go ahead and this is a motion to revoke, right? So let's just go ahead and set it again for July 2nd. And then in the meantime, we can work on reviewing his indigency.
Mr. Schultz, if you'll come sign your reset and then write that out. Tom.
So Mr. Schultz, what Ms. Taverham and I were going to do is I'm going to have you write out a statement regarding what you said. And I'm going to have you swear to that. And then she and I are going to look at the paperwork again and see about appointing you an attorney. And we'll know more information here in the coming days. But regardless, we'll have a hearing come July 2nd, and you'll know before then if you have an attorney or not, okay?
Okay, I hope so, but I don't have the money for it, Joe. I don't even have hardly anything. I don't have pot to piss it.
I understand. I understand. She and I are going to look at the paperwork again. But I need you to fill out that statement for her, okay? All right, Ms. Taverham, is Mr. Schultz the last one at the jail?
Yes, Your Honor, and then we will ask them to bring Mr. Huddleston over.
Okay. All right, we'll go ahead and conclude our jail Zoom, and I'll stand in recess until Mr. Huddleston is over here for the hearing on the protective order.
Okay, thank you, sir.
You're welcome.